Hello, my name is Matthew Rendley, and I'm one of the co-heads of the State Litigation Group at Loopster-Nixon. I'm here to discuss the role of Amicus Counsel in guardianship applications. Guardianship applications are tricky, to say the least. They are encompassed by a variety of different statutes. They pertain to the autonomy of individuals, and they particularly can be emotional. When you're dealing with a guardianship application, you're going to need to assess which realm of decision-making you're dealing with to start. Is it property management or personal care management? And also, you have to assess the subject of the guardianship. Is it a minor, someone under the age of majority, which is governed by legislation, or is it an adult, someone who is not under the age of majority? If a child, then you have to look to, for property, the Children's Law Reform Act. If it is guardianship of property over an adult, you'll be looking to use the Substitute Decisions Act. Where dealing with healthcare substitute decisions for a child, you'll look at the Healthcare Consent Act. And so too will you when dealing with substitute decisions for an adult, but the appointment of a guardian and their governing regulations and duties will then be governed by the Substitute Decisions Act. So once you've determined the subject of the guardianship and which legislation you are moving under in order to have the statutory authority to be appointed guardian, you then have to determine whether or not you have the required evidence. And so the evidence, as we know, is put into the record after a notice of application is issued, and it's put in through an affidavit or multiple affidavits. Your notice of application needs to be very accurately particularized and served on the required individuals under the Substitute Decisions Act and or the Children's Law Reform Act. It cannot be stressed how important the issue of service is on the individuals, because anyone who has standing at law to appear and comment on a proposed guardianship appointment needs to either have notice or have notice waived. Once you've then particularized your notice and set up the grounds for the reason of incapacity under each realm of personal care or property management, the evidence, as I've said, will go in the form of an affidavit, and that will support whether or not the subject of the guardianship has the required capacity based on a particular test as set out in the governing legislation. So I'm going to now deal only with adults moving forward. In dealing with adults regarding their incapacity to manage property, there is a particular enumerated test in Part 1 of the Substitute Decisions Act. In order to support an application to demonstrate to the court that a declaration of incapacity on that ability to manage property should be made, the applicant must have satisfactory evidence which should come in the form of a capacity assessment from a registered capacity assessor. And in order to obtain that evidence, you should assist the applicant, as you are amicus, in knowing that there is a registered roster of certified assessors on the provincial government's website. One of those assessors should be contacted, and before meeting with the subject of the guardianship, there should be an order granted allowing for that assessment to take place. The precipitating orders that you would get before the assessment would take place should also be an order for Section 3 counsel if necessary and appropriate in the circumstance. Section 3 counsel is the appointment of a lawyer for the alleged incapable. The reason why the term Section 3 counsel is used is because the right to counsel is found at Section 3 of the Substitute Decisions Act. The reason why that is in legislation is because, of course, where someone is incapable of managing property or another specific task, such as instructing counsel, a lawyer would be reticent to act for such an individual. But where the public guardian trustee has been delegated the authority by a judge to appoint, well, by the legislature at the direction of a judge, to appoint counsel for the subject, that counsel can rest easy knowing, and I say easy lightly because it is no easy job being Section 3 counsel, but that lawyer can act knowing that the subject of their retainer is deemed to have capacity to instruct them for the purposes of the application. And the reason why that is so important is so that the subject of the guardianship has a voice. Where possible, in all instances, an individual whose autonomy is being sought to be taken from them by way of a declaration of incapacity ought to have the opportunity to go before the court, give the consent to their appointed guardian, if able, or at least give their preference and wishes to the extent capable. So once you have Section 3 counsel appointed, they're then going to meet with the subject of the guardianship and discuss the request for the order for the assessment. If the subject of the guardianship can consent to the assessment under the understanding of rights advice about the ability to refuse to consent to an assessment, then if they do consent, you might not need an order. If they can't or won't consent, then you may have to go back and revisit that order. But either way, the assessment is going to be the necessary piece of evidence, as well as other supporting medical evidence that's going to inform the assessor. But really, it's the assessor's opinion that will instruct a judge in a finding of fact regarding incapacity. So there are instances when there are competing guardianship applications, and when there are competing guardianship applications, the court's going to obviously have to do a best interest analysis, and the court is going to have to look at the different management plans where it's a regulation of how a guardian is going to deal with an incapable person's property moving forward under guardianship. They have to prepare what's called a management plan, which has a particular prescribed form under the Substitute Decisions Act. That management plan has to get approved by the public guardian trustee and then put forward to the court. The assessment of who ought to be the guardian is, of course, going to take into consideration the proposed guardianship plan, management plan for the property, as well as the relationship of the proposed guardian to the subject of guardianship. And this is where it can get quite hairy with conflicting family members and hostile family members coming in and making accusations, often about abuse, between proposed guardians. And it's up to Amicus and the court to determine what types of allegations need to be tested on cross-examination or not, and sometimes where there are not sufficient resources between the parties, that can be a motion for directions in and of itself. Where there is a proposed guardian for the person, there is a counter similar form that's filled out and consented to by the public guardian trustee called the care plan. The care plan describes how the proposed guardian plans on dealing with the subject of the guardianship's ongoing and current physical and perhaps medical needs. And the care plan and the guardian and the management plan often need to get revised as the subjects of the guardianship's circumstances change. And as it gets revised, that's either on a return application, on the consent of the public guardian trustee, or it can be dealt with in a passing of accounts application if that public guardian trustee won't consent to the form of informal accounts or ongoing proposed care plan adjustments. When preparing or assisting the applicants in preparing guardianship application materials, you should direct them to precedent materials. I find that the Law Society annotated guardianship application materials and annotated judgment, because the judgment on an appointment of guardianship has to be very particularly crafted, including the public guardian trustee's direction for appointment of Section 3 counsel and ongoing oversight of the management plan and requirements to allow for passings of accounts and ongoing review, and if there's compensation. There's a whole host of particular requirements that are outside the breadth of this video, but that need to be understood and included. And I find the Law Society annotated guardianship application materials to be quite helpful in explaining in layman's terms how the material should be prepared. As a friend of the court in assisting in these types of guardianship proceedings, it can be quite time-consuming. So you need to be mindful, of course, of the obligations to the court as the appointed amicus counsel, but as well as to, your own practice and mental health. Try and stay out of the fray as much as possible where it goes to detailing facts in the affidavit and there are accusations of abuse or neglect and mistreatment. That's for the parties to put in if they so choose. It's not for counsel, amicus counsel, really to wade in on what is or is not a true fact. At least that's how I've been approaching the role. I try to tell the party what the required tests are, that there are particular legislative tests for the ability to manage property, as I've identified in Part 1 of the SDA, as well as a particular test for managing personal care in Part 2. To advise on what a notice of application is, how it's structured, what the grounds of challenge are, that a guardianship is a statutory course of last resort. So if there is a subsisting power of attorney for property or personal care that is in force and effect, that document needs to either be set aside as void ab initio, or the attorney and as well the alternate attorney appointed thereunder, if done by a capable grantor, needs to be removed before you can even get to the threshold of appointing a guardian. So I tell the party the required legal framework, show them how it's to be set out, and then when it comes into filling the facts, that's really on them. as a friend of the court in assisting with a factum, you can try and best edit which facts should go into the overview or fact section of the factum, keeping in mind the 25-page page limit. So that's when you can, advise the party that, yes, you've put your facts in, you've sworn your evidence, but maybe let's try and cherry pick with keeping, obviously, a consistent outline of facts, but let's try and take what's maybe more persuasive and on point to the issue. They might take your advice, they might not, but that's your role as amicus. And then in dealing with the legislative requirements and legal tests and governing case law, there are very good materials as well from the Law Society, as well as lots of different firms' websites and publishing guides and draft materials, as well as the draft orders on the estates list website. So those are the tools I would look to. That's how I would try and speak with the parties about your role as amicus. And thank you for your assistance to the court in participating in this program, because guardianship is a very difficult but necessary area of our law, and we're lucky to have participants who are willing to help out the court in those matters. Thank you.